Now, the House of Representatives has introduced an act to address building collapses, penalize abandoned contracts, and enforce compliance with awarded agreements. Lawmakers emphasize the need for stricter building codes, contractor accountability, and better oversight in the 2024-2025 budget to prevent inflated costs and incomplete projects. This comes amid rising concerns over infrastructure failures and uncompleted government projects. Additionally, the House is reviewing a bill to separate the roles of the Attorney General of the Federation and the Minister of Justice. The bill seeks constitutional amendments to ensure the Attorney General is an independent legal officer, distinct from the political advisory role of the Justice Minister. The House also confirms the bill aims to improve criminal justice efficiency and reduce political interference. For a discussion about the move by the House of Representatives to separate the office of AGF from that of the Minister of Justice, its impacts on dispensation of justice and the judiciary, we have former Attorney General of the Federation and Minister of Justice, Mike Aondoakaa. He will also be speaking on the need for legislation to safeguard building collapse and abandoned contracts. Many thanks for joining us, sir. Good afternoon.
Good afternoon.
Now, from your observation, what specific conflicts of interest have risen based on the combination of the AGF and Minister of Justice roles?
Well, thank you very much. First compliment of the season. Section 150 of the Constitution, 1999 Constitution, I don't know the nature of amendment they intend to do to that office, because specifically the office of Minister of Justice is not there in Section 150. So I keep wondering what they intend to amend. If you read it, said there shall be Attorney General of the Federation, who shall be the Chief Officer of the Federation, and shall be a minister in council. So I don't see the conflict. I don't see where they are going to do amendment. If they want to create a constitutional office of Ministry of Justice, it's a different thing. There's no Minister of Justice in the Constitution. It's just like Minister of Finance, Ministry of Works. If you read the Constitution, they keep talking of amendment, but I don't see where they can situate the amendment. Though the National Assembly has the power to create a ministry, but they have not done so. There has not been any Ministry of Finance. Those ministries have been left as an executive function of the incumbent president. So I don't see the conflict that they keep talking, except what I am reading is different from what they are reading. Section 150 says there should be an Attorney General, shall be an Attorney General of the Federation, who shall be Chief Law Officer of the Federation, and shall be a minister in council. If Attorney General is an Attorney General and he does not go to council, how can he advise on legal matters? The issue of Minister of Justice is an executive creation with the mandate given by the President, which the President also exercises powers under Section 5 through ministers, which he has added to the Attorney General. The Constitution never created him as an Attorney General and Minister of Justice. It created the office of Attorney General only. Just like you have Minister of Finance, these are executive functions. Now there's Minister of Finance and Budget and Coordinating Minister. Are they going to amend it so that they will separate because the President has added those ministries? They should read way before we go into talking of amendment. I don't see anything. If they want to make a law, but how will you make a law for how the President will function, exercise his executive function?
All right, well said.
National Assembly cannot go making the law and saying create Office of Finance in the Constitution, create Office of Commerce in the Constitution. These are executive offices created by the Federation. The only office created by the Constitution is the Office of Attorney General. Minister of Justice is not there. So what are they amending?
All right, well said. But the same constitution you talked about in the subsection 2, item 4 of that same constitution, it says that for the alteration of that particular law to be made possible, certain requirements must be met, such as a 2/3 majority of the House. And of course, it means that there is a possibility for this office to be created as long as this requirement is met. What potential constitutional challenge do you foresee being someone who has occupied this position before?
There's no conflict. The office of the Attorney General is constitutionally created with responsibilities. But the office was not created to exercise powers of Attorney General and Minister of Justice. The Constitution recognized Attorney General as Attorney General alone. But in addition to making the Attorney General the chief law officer, he said he should be like a minister in council, which is, I don't see where there's conflict that you have to separate. They have the power to create any office, but I want to point out to you that Minister of Finance and Budget and several other things added to the budget has not alluded any conflict that will require constitutional amendment, because that ministry is an executive creation. Ministry of Justice is an executive creation. It's an assignment given to, additional assignment given to the Attorney General by the President, not the Constitution. Minister of Justice is an assignment given to the Attorney General by the President, not the Constitution. So what are they really amending? That is my big question. You can read the Section 150 again over and over. Where is Minister of Justice mentioned there that you want to separate the office? So which office do they want to separate?
So we can't...
All right.
Sorry to just butt in here. I just wanted to get some clarification as regards the caveat created with that same section, that same constitution you're talking about, saying that if there needs to be an alteration, 2/3 of the House can make an alteration to that particular office. You don't see that as a possible loophole to latch on?
No, I say it's possible, but if Section 150 has not mentioned Minister of Justice, so if you are making an alteration, what are you making that of? Exercising the power given to you to make alterations of the Constitution. So which office are you altering? There's Minister of Justice is not there, so how are you going to make the alteration?
All right, Mr. Aondoakaa.
Except that in making an alteration to create a new office or Minister of Justice. If not, Minister of Justice is not in the Constitution. It's an assignment given to the Attorney General by the President, just as the President assigned responsibilities to the Minister of Finance, Minister of Works, Minister of Commerce, Minister of National Planning. So I don't see where they want to create, except they want to introduce a new office and give it a constitutional responsibility. As of now, there is no Minister of Justice created by the Constitution. The Minister of Justice is an assignment given by the President. Except they are going to say that, look, once you are making Attorney General, you should not be, meaning the President should not assign the Minister of Justice to you. But that will be far-reaching interference with executive function.
All right. In addition to that subject, Mr.
Aondoakaa,
Aondoakaa,
how to create ministries.
we hear you on that. Thank you. The other subject you're here to discuss is also the Construction Act, and I'd like us to deviate to that for a moment, please. Now, regarding that, what specific penalties would effectively deter the issue of project abandonment?
Thank you very much. This is a problem of the country. I have read Senator Jimo Ibrahim, PhD, double PhD, thesis on abandoned projects, mega projects. And I also was privileged to attend his last lecture at Oxford University. I was in attendance. He stated that we have over 11,000 mega projects which constitute up to 60% of our debt ratio. That is alarming. That means you have put money in projects that are mega projects, and these projects are not executed or unfairly executed or abandoned. For instance, he pointed out of Aondoakaa steel plant, which has gone up to about over 40 billion, and nothing has happened. But the truth is that there has not been any framework, a construction law that takes care of this and makes people culpable. There's supposed to be a construction law different from the architect, are different from surveyor, that makes people who implement, who conceive this project with the intention that it should fail, culpable. And the penalties should be both, including the contractors, who, whether international, local contractors or international contractors, there should be penal provisions that makes them liable to pay compensation and also makes it liable so that they can have imprisonment. If that is done, there will be deterrence. For instance, you have situations where contractors are giving road contracts to or road maintenance. You pass 6 months, the road is being maintained, and after 3 months, the road is damaged. There's no law to punish those people. There's no law to punish the supervisors who never ensure that the road is being repaired according to specification. There's no law.
Well, speaking
Therefore,
of
there
law,
should be a law that specifies a framework. There's a law, a construction law itself, not an ad hoc law, and a comprehensive construction law that takes care of the conception of the project, the supervisors, project managers, all of them, their responsibility should be there with penal provisions, and the contractor's liability after a certain period of the contract. It should be clearly stated that if this contract is given to you and this contract fails upon this period, you restitution, you pay back the government and you go to prison.
Thank you for elaborating on that.
This is something that is very, very important, because if the National Assembly has identified it, is a very happy development.
Okay, great.
I have gone through certain roads here. I'm giving you road as a busy minimal thing that everybody sees. You pass through a road where maintenance is being done, either by FEMA or a contractor awarded by FEMA. After 3 months of the maintenance, you see potholes, and nobody is held liable. There's no law that you address or situate these people and deal with them under failed construction. Under failed constructions, laws should address that if you have a contract and the contract has a framework and you execute it and it has failed within a period that's not acceptable, you should be criminally held liable, and also you should be liable to pay compensation. These are the kind of construction law. They are everywhere traditionally. And we also need to involve project managers. We don't have a project management is now becoming an international course which everybody is attending, because apart from the fact that engineers, architects are involved, surveyors are involved, you have skilled project managers whose duties are specified by law and who are trained to manage this project and ensure that after the project has been completed,
based on time, and well, we have limited time with you, we know you could do justice to this topic very widely, but let's narrow it. Let's talk about quality control for a moment. How can proposed construction law ensure quality control without creating bureaucratic bottlenecks?
There's no question of it's a law which can be enforced by the body. You have all laws, but EFCC have the power to enforce laws that lead to corruption. Not the EFCC Act is just an act that embodies that to give effect to other laws that have created penal provisions that aids or create penal provisions that are deterrents for money laundering. So we can have a construction law like that, which embodies quality control, quality assurance, project management, contractors' failure. And if it fails, the appropriate bodies will have a law. Whether quality control, we have a law, a comprehensive law to deal with the situation. That is how we have dealt with the issue of criminality. EFCC Act or ICB Act creates a framework to enforce criminal acts that are fraudulent constitute money laundering created even under penal code or criminal code or other even tax laws. This is how we organize ourselves. That body is there, but the laws does not mean that it must be tax people that we deal with it. Where a tax evasion becomes a fraudulent act that amounts to money laundering, EFCC can use the tax law and charge people to court. That is the kind of thing I'm talking of constructing law.
All right, we do appreciate
organic framework on failures.
Thank you very much for your time on Newsday this morning. Former Attorney General of the Federation and Minister of Justice, Mike Aondoakaa.